We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
Court looked at Section 9 of the Fair Trading Act, considered the case law, and it framed the legal question that was asked of the court on review. So turn to paragraph 59. The court said in this case, the question before the district court was whether in the particular circumstances there was misleading or deceptive conduct by Ms. White. Then, Your Honour, the court went on to ask whether it was open to the district court to make certain findings regarding Section 9 of the Fair Trading Act in the circumstances. And in the McBride case, Your Honour, the judicial review was dismissed and it found that the district court was open to make the findings that it did. Now, Your Honour, I'll come back to using the framework for analysis of error of law in this way and in application to these facts in this case. In relation to these grounds in this case. Your Honour. So I do think there's a helpful case to provide a framework on which to work from. The second ground for review is error of fact. The decision maker must have the correct facts and those facts must logically support the decision. Now, when a mistake of fact does not apply as a basis for judicial review, when there is one or more view of facts that can be reasonably held. The court has also noted in relation to specialist tribunals that reasoning and conclusions on the material should not be revisited. Alternative conclusions substituted unless there are strong and highly persuasive reasons to do so. So, in the context of judicial review, Your Honour, error of fact is, for example, where it can be established that there is a lack of evidence supporting a finding of fact, that the decision is based on inadequate fact, that the decision maker has ignored or disregarded an incontrovertible fact, or as referred to in the McBride case, sometimes in exceptional circumstances, there might be a clear mistake of fact which requires a remedy. And the final ground, Your Honour, is for review is treated as unreasonable. Your Honour, turning to paragraph 14 of the Council's submission, I would like to touch on the fact that in these particular circumstances, appeal from the district court is not available through parliamentary intention. So Section 16 of the Schedule 1 of the Motor Vehicle Sales Act 2003 states in the decision of the district court on appeal on the tribunal is final. However, the right to apply for a judicial review is specifically reserved. In light of this specific prohibition regarding further appeals, Council submits it's particularly important to consider the differences between an appeal and a review. A review is concerned with the legality of the decision, addressing the process and procedures of the decision making. Council submits the court must be very careful to confine the grounds of review to just that, and not to broaden any issues to a scope which might be more relevant for an appeal. Turning now to the first ground regarding error of law, Your Honour. The decision of Judge Harrison regarding the interpretation of Section 21C is set out in paragraphs 20 through 26 there, and I've also repeated those in my submission this morning. I think that is quite important, and I would like to read that out. At 20, Judge Harrison states, the issue, it seems to me, is whether the right to reject a vehicle is lost if any damage, even of the slightest imaginable, such as a scratch to the paintwork, justifies the finding the right of rejection is lost. I do not accept that the legislature intended the effect of Section 21C to be so harsh. Damage is defined in the new short Oxford Dictionary as loss or detriment to property, reputation, etc. 2. Harm done to a thing or physical injury impairing value or usefulness. At paragraph 22, he goes on, it must be remembered that the right of rejection only arises after a finding pursuant to the Consumer Guarantees Act that the vehicle supplied had faults that breached the acceptable quality guarantee, and that those faults amounted to a failure of substantial character. I cannot imagine that the right to reject a vehicle is lost because after purchase insignificant damage may have been caused to the vehicle. In my view, it must be established on the evidence that the damage impairs the value of the vehicle to the extent that it would be unconscionable to permit the purchaser to reject it. That will be a question of fact for the tribunal in each case. And then lastly, at 26, there was no challenge to the factual findings of the tribunal. Mr. Murphy's point was that the minor damage identified had to result in the loss of the right of rejection because Section 21C is mandatory in its terms. I do not accept that it is so harsh for the reasons given. The damage relied upon must amount some loss of value to the vehicle or reasonably significant cost of repair, justifying the finding that damage greater than fair wear and tear has occurred. It is Council's submission that Judge Harrison did not err with regards to his interpretation of the relevant law. He correctly identified the court's task regarding the interpretation of the Act. Submissions filed prior to the appeal hearing for both the appellant and the respondent supported the question of law as framed by the judge. And then you can refer to those submissions in the common bundle. Judge Harrison engaged with the context of the legislation, and it is submitted the applicant is unable to show the judge harbored any misunderstanding of the legislation for the purposes of the appeal. The judge considered the case law regarding previous tribunal decisions and a dictionary definition of damage. After taking into account these usual considerations in the course of the statutory interpretation exercise, Judge Harrison upheld the interpretation in the tribunal and concluded in order for a consumer to lose their right to reject the vehicle, it must be established on the evidence that the damage impaired the vehicle, so the value of the vehicle to the extent that it would be unconscionable to permit the purchaser to reject it. Council submits that this conclusion is consistent with the case law and one that was clearly open to the district court to make on the facts that were accepted by the appellant. Applying the methodology in the McBride Street case, the judge followed exactly that same process. He reviewed Section 21A of the Consumer Guarantees Act, considered the case law, framed the legal question, and reached a finding that was open for the district court to make. This is an uncontroversial decision that does not reach the threshold for an error of law. Remembering that judicial review for this ground cannot be used to disturb the district court's factual finding. It is Council's submission that the applicant's submission regarding the interpretation of Section 21A and that it's mandatory in its terms was the exact argument that was put before Judge Harrison in the appeal. Judge Harrison rejected this argument for clear reasons, and it cannot be a reviewable error of law. Turning now to the grounds of error of fact. No. The applicant's second ground for review is that Judge Harrison's decision relied on the wrong facts. And now at paragraph 24 of submission. In part by disallowing the application to admit new evidence. Council submits that the crux of this ground in fact appears to be the applicant's assertion that Joden brought the appeal on the grounds of law and fact, and that Judge Harrison erred in his determination to proceed on the basis that the appeal was only on the grounds of law. It is Council's submission that everything that flowed from that decision is not, in fact, an issue in this judicial review before determining whether that an error occurred at that step in the process. Right? Referring to the applicant's submissions for this hearing, Your Honour, paragraph 52 of the applicant's submissions. Your Honour, the applicant has framed this a second round and broken it down into 4 separate sections. The first is that Harrison erred by upholding the tribunal's decision that the damage was caused to the vehicle's wheel was minor. The second, that the damage to the vehicle was in fact more significant. The third, that Judge Harrison erred by failing to admit the evidence, essentially. And the fourth, that Mr. Purcell misrepresented or withheld material facts. Your Honour, it's submitted that part 1, 2 and 4 of that paragraph really asserts Judge Harrison made an error of fact by determining that the tribunal's findings regarding those facts, namely the damage, should be upheld. Part 3 of that paragraph is slightly different, Your Honour. There the applicant's ground asserts Judge Harrison disregarded relevant facts, namely the fresh evidence of photographs, and that was an error. In Council's submission, before the court can consider whether a ground of review based on error of fact can proceed, it must carefully identify whether the district court actually made any findings of fact in the appeal. That is, whether facts were a live issue in the appeal. The applicant submits, in Council's submission, this is the key distinction between the positions of the parties in this review. The applicant submits the appeal in the district court was brought on 2 grounds: that the tribunal was wrong in fact and law. Noting the applicant was at all times represented by its director, Council submits the notice of appeal is actually ambiguous as to whether the appeal actually includes a ground in relation to the facts. I have repeated the section of the notice of appeal here for Your Honour. Shall I read what paragraph you're on? So apologies, on paragraph 28 of Council's submission. And I'm referring to the notice of appeal that was filed in the district court.
Yes, got that.
And there, at paragraph 2 of the notice of appeal, the appellant relies on the following ground: that the decision is a breach of statute law and is therefore ultra vires in nullity, and B, that the vehicle was damaged following delivery, thereby invalidating any recession application. The Council submits that the first ground under ground A clearly relates to an interpretation of the law. The second ground is slightly more ambiguous. It could be a reference to an appeal on the facts in relation to the findings of the tribunal regarding the damage. However, it could also be interpreted as supporting the first ground, namely the submission that the law should have been interpreted in a mandatory manner, and the protection lost as soon as damage was found.
I mean, your second interpretation seems the more logical one, I would have thought, just because says relies on the following grounds. The decision is in breach of statute law and is therefore ultra vires and a nullity, and that's the argument that Section 20C means that if there's any damage, then you must you lose your right of rejection. And then B, that the vehicle was damaged following delivery, thereby invalidating any recession application. That's kind of if I'm right on the law, then the vehicle was damaged, and therefore the right to reject had been lost. So really they're both limbs of an error of law argument, because there's actually, as I understand it, there's B isn't an issue in dispute because it's clear the vehicle was damaged. I mean, it was found to have been damaged by hitting the curb. So that's actually not, he's not appealing against that finding of the tribunal, because if the tribunal had found the vehicle was not damaged at all, then you might appeal and say, well, actually the vehicle was damaged. But in fact, the tribunal found that the vehicle was damaged, and Mr. Preslip admitted that the vehicle was damaged. So I would interpret that as both those limbs actually relate to the error of law, because he doesn't need to appeal about the damage, because that's actually common ground between the parties. And he's not raising an issue there about the extent of the damage, because his argument is that it doesn't matter what the extent of the damage is. So in the district court anyway, his argument is it's irrelevant what the extent of the damage is. Any damage precludes a right of rejection. So I struggle with the proposition that B is raising an error of fact, because what would the error of fact be? He's not. They've said the vehicle was damaged, and he's agreeing with that. So I can't. It could only be an error of fact. I would have thought if the tribunal said the vehicle wasn't damaged.
Your Honour, you've hit the nail on the head, and that is how Judge Harrison proceeded. Counsel's submissions were simply trying to, I suppose, be slightly generous to the interpretation of the notice of appeal. However, that was simply not the way the case was presented in the district court. It was presented on the basis of an error of law. That was how the papers were presented, that was how the submissions were presented. And the rest, the following paragraphs in my submissions go through those in some detail. It wasn't until the interlocutory application was made where it has to be considered on the face of it, applying to adduce further evidence in relation to its damage. Judge Harrison then clearly became alive to the possibility that the appellant's case may be more than just a ground on appeal of law. But His Honour, Judge Harrison clearly discussed that with the appellant, because his decisions refer to that fact. They refer to that is not Mr. Murphy's case now. They refer to the very live possibility that that could have been relevant evidence for a ground of appeal on fact. But His Honour, Judge Harrison says, but that is not the case here. So there was clearly a process that Judge Harrison followed in reviewing what was being presented to him. If there was an appeal on the ground of fact at all live before that point, in counsel's submission by this stage it had been abandoned. However, there is nothing else on the paperwork apart from one section in the appellant's submissions before the interlocutory hearing that refers to any dispute on the fact. So, Your Honour, the question is not should the appeal have been run differently, should the appeal have included a two-pronged attack. That cannot be a reviewable ground. Perhaps it should have been run that way, but that is not a ground for review, judicial review. We have to be very careful here to narrow the grounds to what is appropriate and lawful to maintain a judicial review. This is not an appeal. It cannot be another appeal that has been specifically prohibited by Parliament in this case. So, Your Honour, turning to paragraph 36. of my submission, we've just, in essence, covered this matter, but Council has to concede that the fact that new evidence was being sought in the district appeal to be introduced must have led the court to be alive as to whether there was a second ground of appeal in relation to the factual determinations of the tribunal. However, after careful inquiries were made of the applicant as to the ground of the appeal, Judge Harrison found there was no basis to admit the evidence. And he says in Mr. Murphy's case today that the decision was wrong and the appeal should proceed on that basis. And he specifically alludes to the fact that on the face of it, further evidence may be relevant to the right of the petitioner to reject the vehicle. However, Mr. Murphy says that is not his case. His case is that the tribunal's decision as it stands is wrong by reasons of the findings that the damage referred to is insufficient to warrant an application of Section 21C of the Act. So it's Council's submission that Judge Harrison ascertained the crux of the appeal in a perfectly orthodox way and proceeded to make his decision in relation to the interlocutory appeal on that interlocutory application on that basis. Turning to 38 of paragraph 38 of my submission this morning, at the substantive appeal, the applicant restated its grounds for appeal, restricting again the appeal to the interpretation of the Act. No argument was made in relation to the type and nature of the damage that had occurred to the vehicle or the tribunal's findings in that regard. Judge Harrison issued his decision in relation to the substantive appeal on 30 June 2020. He noted the jurisdiction for bringing appeals included grounds that the tribunal was wrong in fact or law, or both fact and law, and that he did not understand Mr. Murphy to challenge the tribunal's findings of fact. And Judge Harrison concludes at paragraph 26 of his decision, there was no challenge to the factual findings of the tribunal. Paragraph 27, that is not the case here according to the tribunal's findings of fact. It is not otherwise misinterpreted of the law, and as a consequence the appeal is dismissed. So, Your Honour, the applicant has now framed its position for review conveniently in the alternative, that any damage causes a loss of the right to reject, but in the alternative, that the damage was actually more serious than the tribunal found. The applicant says that the District Court was wrong to exclude the fresh evidence, and that is a ground for the review on the basis of error of fact. He says that Judge Harrison dismissed the application to adduce the photographs on the basis of a misapprehension of a comment made by Mr. Murphy, and that in fact at all times the applicant intended the appeal to be progressed on both the question of law and fact. With respect, this simply was not how the applicant presented its appeal in the District Court. It is Council's submission that the applicant's assertion both grounds for appeal were alive is simply not supported by the evidence, and the District Court made no such misapprehension. The applicant made decisions as to how it ran its case on appeal in the District Court. It cannot now rerun its appeal through the back door of a judicial review process. The applicant's assertion that Judge Harrison had erred in upholding the tribunal's findings that the damage was minor and that this amounts to an error of fact has to be flawed in Council's submission. Judge Harrison did not uphold the tribunal's findings in relation to the factual issues because those matters were not challenged and they were not a live issue before the court. It follows in Council's submission that when considering the material before the District Court, the applicant's own presentation of its case on appeal It is submitted, the applicant can now raise a ground for review which relates to the error of fact. Paragraph 47 of Council's submission, Your Honour. Any submission that an appeal on the facts was and should have been a ground for the district court. Council submits amounts to an assertion that Judge Harrison willfully ignored or disregarded the ground of facts for an appeal. Such an assertion of bias is an extremely high bar, and Council submits it cannot be met on the evidence before the court. Given the appeal's only limitation to the district court, the only question on judicial review in relation to this ground is whether it was properly open to Judge Harrison to conclude the appeal was only to relate to an interpretation of the law. Justice Palmer has admitted the further evidence of Mr. Murphy's photographs for the purpose of this review. It is Council's submission that this purpose is to provide context for Judge Harrison's decision in the interlocutory proceeding. The veracity of that evidence as against the tribunal's findings, that is, whether it can be argued the photographs show further or different damage to the findings of the tribunal, cannot be a proper purpose given the context of judicial review. The sections of the applicant's submissions that refer to analysis of physical parking mishap and damage to the vehicle, the amount of damage, the type of damage, and the tribunal's findings, simply not relevant to judicial review and broaden the issues beyond this court, beyond review. The final ground that the applicant pleads is unreasonableness. And I've set out brief submissions in my submissions at paragraph 50 and 51. So to conclude, Your Honour, Council submits that the grounds for judicial review need to be carefully considered in cases such as these and are usually narrow. The applicant has failed to show the district court either in law or was unreasonable in its decision. Judge Harrison's decision for both the interlocutory hearing and the substantive appeal provide clear reasons and are supported by the documents before the court. The applicant can now raise matters that more properly fall within grounds for a second appeal. It is submitted there are no grounds to review based on an area of fact, as these matters were not an issue before the district court. Reverting to the core principles of judicial review, Council submits there are reasonable grounds for Judge Harrison's decision. His decision was measured, reasonable, and uncontroversial, and there are no grounds for the court to intervene.
Thank you, Mrs. Fallback. Mr. Beard, aye?
Just going to the notice of appeal, paragraph 2b on page 9 of my really three submissions, and Your Honour's comments about the second ground being I merely read there that the vehicle was damaged. It doesn't say whether it was the parking incident or what incident. It was just damaged. It doesn't go any further or specify.
And that wasn't a dispute.
Yeah.
I mean, that's not factual. I mean, he's not appealing a finding, for example, that he's accepted the factual findings of the tribunal, which included that the vehicle was damaged. So the argument, as I read it, is that the tribunal's misinterpreted the law because the law says if the vehicle's damaged, you lose your right of objection. here the vehicle was damaged, so necessarily follows he must have lost the right of rejection. And it's not a dispute that the vehicle's damaged, it's common ground that the vehicle's damaged.
Yes, Your Honour. All I'm saying is you add the lights and the bumpers and with that damage referred to at 2B, and then you get your factual.
But he didn't run in the district court what I put to you, I think, at the outset as the alternative argument you could have run. So you could have run an argument on appeal. They've erred in law, and any damage whatsoever precludes a right of review. But if I'm wrong on that, then the level of damage here was exceeded what was reasonable, and therefore, but he didn't run that second argument in the district court.
But,
he only ran the first argument.
But Section 2B would be wide enough for him to say.
Well, Section 2B, he's just saying the vehicle was damaged, which is not actually in dispute. But it needs to be there to win your appeal, because your appeal is basically A, they've got the law wrong, and in fact any right of damage precludes the right of rejection. B, it exceeds that threshold because the vehicle was damaged and it's not disputed it was damaged, thereby invalidating any recession application. There's nothing in the submissions or the notice of appeal or the judgment that suggests that he ran an alternative argument that said, if I'm wrong on the law and there is a right, you only lose the right to reject if the damage exceeds ordinary wear and tear, then I'm saying that the damage was greater than what the tribunal found. He's accepting the tribunal's factual finding and just running a pure legal argument. That's how I read what happened in the district court.
As Your Honour pleases, I would say that a lay litigant prepared that Part B, so I would be generous with my interpretation of that.
Well, I think though it's not just that, is it? It's looking also at the substantive decision, the decision on adducing further evidence, the transcript of the hearing. Look at all those things. You can see whether he in fact did run an argument in that court. The fallback argument, which you're right, which a lawyer might run, which is, if I'm wrong on the law, then I run a factual argument that the tribunal was actually wrong about the extent of damage and it exceeded ordinary wear and tear. But in fact, as I read things, he accepted the tribunal's factual findings and said, well, based on those factual findings, it's common ground that there's damage, and if you accept my interpretation of the law, then he's lost his right to reject. But anyway, I mean, I'll go back through the transcript again and have a look and see if there's anything in there which might suggest that he did flag that alternative argument, which he's really advancing in this judicial review.
Yes, all I was reiterating was the could be factor referred to in paragraph 13. Now, just in summation, the tribunal ruled that Joden would pay for the car before Joden could appraise the vehicle and find out the extent of damage, whether it was minor, major, or any qualifier. Joden asked on many occasions to appraise the vehicle before the hearing, before it was called upon to pay, but that was denied consistently until Mr. Prislip's lawyer granted access. And then when we did get the evidence, it was denied in the district court, despite Judge Harrison's noting that it may be relevant. Mr. Prislip has never denied that Mr. Murphy's affidavit evidence showing the significant damage is incorrect, and Joden submits that Mr. Prislip has not come to court with clean hands in terms of the damage to this motor vehicle. And that's
Well, thank you both, council. I'll reserve my decision on that. Thank you both for your submissions, and I will deliver that through the registry in the usual way. It's unlikely to be court finishes up Friday next week and on duty judge next week.
I might point out right here that nowhere during this hearing, nowhere during this hearing was I mentioned as being at the June hearing as a support person for John. And this comes into play very, very well, because after this court case, I have the decision made by old Sarah Katz. And she never wrote that, because they pay particular attention to the fact that I was also a support person in June for John. No, I wasn't. I was never introduced as that whatsoever. I was there in the back of the courtroom just observing. So, you know, receiving information in any form I saw fit. Gary didn't even know I was in the back of the courtroom. So, but for some reason, it's written about in the judicial decision. So this shows just how ridiculously stupid. Right, as far as I'm concerned, John should just do a judicial decision on the initial tribunal's findings, because they found that it was due to ordinary wear and tear when they're fuck ass wrong. And one thing they missed out on doing is actually looking at the vehicle. Other times John's been through the MVDT, they've come down and checked the vehicle. This time they didn't. And how the hell did Mr. Prieslip keep getting legal aid funded by you and I to do this? Talk about the court system making money out of you lot.